something went wrong and basically was like $320. My shoes were paying like $75. So I just basically was like, okay, well, whatever. Like I just was gonna chalk it up to luck. And then I figured, well, if she did it accidentally, I could just do it on purpose.
I have to read you your rights. Do you fully understand those rights?
On August 13th, 2025, a responding officer arrived at a Nordstrom location after store loss prevention detained one of their own employees.
Hey.
Yes, the officer's here right now coming in the door. Thanks.
Has he explained everything on the phone, what's happening?
Nope.
Alright, so over 3 different dates, we have the subject doing return fraud for $1,467.
Is this him here?
Yes.
Okay.
We have a written statement, and he's admitted to everything already. He understands what's happening. He understands he's getting
If you wouldn't
prosecuted.
mind, please.
He knows he is he's trespassed, and that we know he is trespassed, and that we are filing charges.
Okay.
Neil will be the one signing charges on this case.
Okay.
What do you need from us? He has video, I know that.
Okay. Do you guys have a
The statement we can't use. We would have to write out the statement for you guys. This can't leave the
Okay,
company.
gotcha. I will get you a form to fill out then. Is this a statement from...
Yes, that's
Sir, put that down, please.
I can't use my phone.
No, put that down.
It looks like a knife. That's.
You can't use your phone either. I can't use your phone right now either. Thank you. Please remain seated right there.
The subject had already provided a written confession before police entered the building. That sequence, private interrogation preceding law enforcement contact, is the first legal issue this footage raises. Under Illinois versus Perkins, 1990, private actors are not bound by Miranda obligations. Loss prevention's interrogation carries no Fifth Amendment constraint. That means every statement the subject made to store security before a single officer arrived is fully admissible without Miranda consideration.
Let me get Neil on his statement.
All right. I have to read you your rights, okay? So you have the right to remain silent and refuse to answer questions. If you're going to make a statement, you may stop at any time. Any statement you make can be used against you in a court of law before making any statement or any time thereafter. You have the constitutional right to the aid of an attorney and to have an attorney with you during questioning now or in the future. If you're unable to afford an attorney, one will be appointed for you before any questioning if you wish. Do you fully understand those rights? Do you have any weapons on you?
No.
Okay. Check, please. Stand up and turn around. Go ahead and bring your hands behind your back for me. Put the backs of your hands together, please. Thank you.
what do you talk? What exit you went through?
It's not going to be like that. It was over multiple days and it's return fraud. So he left out the employee entry these times. So it's an internal thing.
Okay.
I'd like to ask you.
Yeah, I guess at that point, just through as you can.
Yes. Are you banning him from the mall?
Yeah.
Okay.
Tell me what happened.
I'm gonna need to get a booking photo too at some point.
So basically, one day my friend did an incident, so like, she sent me a receipt that wasn't mine, and basically when I returned because I was trying to return shoes. So once I returned, once I was trying to return my shoes, something went wrong, and basically was like $320. My shoes were paying like $75. So I just basically was like, okay, well, whatever. Like I just was gonna chalk it up to luck. And then I figured, well, if she did it accidentally, I could just do it on purpose. So then I just did it like twice more, and
With no item, you just rang out returns. You just ran up returns for with no
like,
items.
Like customer, like if a customer came in, I would just use their old return information. Like, so if they had something from like 2 years ago or a year ago or something really old, like obviously they possibly wouldn't want to return, I would just return that.
Okay. So, help me. When a customer would come in, like and provide you a receipt for a return, or like.
Yeah.
So a customer would come in and return something,
Yeah, or like
and you would facilitate that refund legitimately for them
yeah,
and give them money,
Yeah.
and then you would do it again
yeah, but like
for the wrong amount and pocket that money. You did that for the wrong amount and pocket that money. You did that twice.
Yeah.
Okay. All right. What's the total amount?
It's gonna be 1,400. Get that total. $1,467.18. It's gonna be 3 different return frauds.
Okay.
He's gonna give you guys a detailed statement and a
So
narrative.
does that include he said he did the initial return with, is that correct? You saying
Yeah,
he did the initial return
That
with
was
too much
yeah,
money?
That was an accident. Yeah.
Yeah, everything we went over
Does
in
that-
the total is exactly what he's
So,
talking
so that
about.
amount
yes.
includes
Yes.
the extra from like summer return and then 2 or 3 other fraudulent returns?
So when you were talking to him, you were talking about the 3 transactions
Yeah,
that we
the
were talking
first
about?
one, the accident, the other 2.
Okay, so what we have him signed on and what we'll be prosecuting on is the 3 that we talked about with them, so it'd be the 1,400 and,
So we kept extra money from 1 legitimate return and then facilitated 2 fake.
So the first one was, they were all another customer's sales that were used for a return, not,
Okay.
he was due none of the funds.
Okay. So,
and then
okay.
It was
he
320. The amounts like 3, so equaling to 14.
So was he like,
So basically what he did is he took, a customer came into the transaction, later that day he would use that transaction receipt, you know how you would return an item if you don't want it?
to
He
pretend as
yeah.
if they were coming back
He
and
came,
returning
pretend
it?
returned it to a gift card, and then used it at the places. He did
Okay.
that for all 3 times.
Did you return it to gift card credit for Nordstrom?
Yes.
Did he use them here or did he use them elsewhere?
He used them online and for the E-bar, which is a part of Nordstrom.
Okay.
At approximately 2 minutes 12 seconds, the officer administers Miranda warnings. The advisement is complete. Right to silence, right to counsel, appointed counsel if indigent. Miranda versus Arizona, 1966, requires these warnings before custodial interrogation by state actors. The officer correctly identifies this threshold and complies. However, the officer does not secure an explicit verbal or written waiver before resuming questioning. This is where the procedure becomes legally vulnerable. The Supreme Court in Berghuis versus Thompkins, 2010, held that a suspect who receives Miranda warnings and then speaks voluntarily has implicitly waived those rights. The burden, however, falls on the prosecution to prove waiver by a preponderance of evidence. A documented waiver verbal acknowledgement on camera eliminates that burden entirely. The subject never invoked. Under Davis versus United States, 1994, invocation must be unambiguous. Silence alone does not constitute invocation. The subject's continued voluntary statements after advisement satisfy the implicit waiver standard under Berghuis. His post-Miranda confession is therefore admissible. The core offense is theft by deception. 3 elements are required: intentional deception, deprivation of another's property, and causation. The subject's own words establish all 3. His statement, if she did it accidentally, I could just do it on purpose, satisfies the intent element without ambiguity. He accessed legitimate customer transaction records without authorization, processed phantom returns, and diverted funds to gift cards he controlled. The deception is the false representation to Nordstrom's point-of-sale system that a return was being legitimately processed. The financial loss is the direct result. Under Colorado versus Connolly, 1986, voluntariness of confession requires absence of coercive police conduct, not merely internal pressure or remorse. Nothing in this footage indicates coercion. The officer's demeanor is conversational. No promises, no threats, no deception. The confession withstands voluntariness scrutiny.
While we're waiting, the mall is here. I guess they will be banning you from the mall. We'll discuss that, and he needs to get a couple details from you.
What's your first name? D-O-H-N?
No, it's a phone case.
Can you spell that?
B-A-
Say that one time. And where that's at?
I'm sorry.
City states it. And date of birth?
January.
Yep. Yep.
Alright, so you have a 1-year ban. If you step foot on property at all, that's including the Plaza Center, you will be arrested for criminal trespassing. And I do have to get a photo for our records as well.
So just remember, it's 1 year from the entire mall, 2 years from Nordstrom.
They'll have a copy once they take you and everything like that. Can I just get a second?
Are you doing John?
Two.
Yeah, you can disregard. Everything's okay.
Appreciate it.
200.
Good. Is this your bag of stuff too?
Living scrap jersey. Some of the hours that
Get a photo real quick. I'm gonna do face up.
try to get more detail, you can get it in Alright, have a good one.
Okay, so, I'm pretty sure that's the first station. On the back with.
You print that, that's a typo.
Okay. Sorry about that.
Copy.
You guys have a police report number and whoever's taking the case.
Yes. Box cutter.
This one's his too.
Now before you go, is there anything else in the building that's yours? Except what there's.
There's gonna be a paper coming out of there.
No.
Just also state, you wish to pursue criminal charges and then your information.
Sorry about that.
Everything else seemed okay, just perfumes and lotions and stuff, box cutters right now.
You can go and call all these at the time we contact them.
Figure since he wasn't, just handed his stuff back. And then, I was just asking if I could.
Is this your box cutter?
Yeah.
It can't be brought with us.
It's
Okay.
used to, like, scratch stuff, like, for work. Stuff
No, I
like
got you.
that.
Is that you don't need it right now?
No.
Would you be okay if I just threw it away?
Yeah.
Okay.
Just so you see these are extra witness statements, we're gonna rip them up, that you can write on.
They don't throw things away in here? Oh. I'll put this in there too if you don't mind. Thank you.
Good. We have
Okay.
properties.
All right. Do you have anything at all on your person right now?
And which
Paperwork,
do you guys
phone.
still want video?
Anything at all?
You guys still want video?
Yes.
Okay.
You have a flash over you need one?
You can turn the
Okay.
flash there.
When we get to the jail, they're going to do a very thorough search of you. Okay. Do you have anything hidden on you that they may find in there because it is a felony level
So
charge if that has occurred?
There's like a card.
Did I bring that up? Did I bring that up?
Card.
So we're trying to do that right now?
One of these gift cards.
Yeah.
If then apply at the end of the day.
Is there anything else?
No.
My office is at here.
Yeah, it's down by the food court.
Yeah, is this the
Yeah.
one that
Yeah,
gift
just
card
drop
that
it off. If I'm not in there,
you're carrying
you
the balance
have
of the
my
refunds on?
Yeah, I do, working, yeah.
Yeah, just give me a text or a call.
Buy
Okay.
things
Just
that
let me know.
when I see a receipt next to the E-bar, is that
Yeah, let me just,
What's that?
What are they getting first?
Oh, you had one of the gift cards?
Yeah.
Do you want us,
Yeah.
do you want us to drain it, or?
Yeah.
Okay,
Is this
2 and
you guys need to take that with you.
Yeah, but it's evidence.
Okay, that's good. Just write down that we have acknowledgement that the police have the gift card, and that we're gonna drain it.
No.
Do you need numbers or anything on it?
I'll get a picture of it, thank you.
You able to get a value off?
Cody, do we have the amount that's still on the card?
face the wall there for me, please? Spread your feet out for me.
I mean, it's still on the card, yes. It's blocked to where you can't be used, but it's still on the card.
How much is,
Unblock it if you want, like, spend it with my own. Wondering.
like, can
Excuse
we
me?
print out, can you send me a value of how much is on the card so the police can have it?
Okay.
Yeah, just let me know which one it is.
What does it end in? It ends in,
Come with me. I'm gonna keep a hold of you so you don't fall. I'm gonna walk right out to my car, okay? I'm not trying to perp walk you.
this is what it feels like. It feels like coworkers. I hope.
Have you ever been arrested before?
For stuff like, you know, like my life. Not like you're a criminal.
Wow. On your,
Oh, thank you. Just a quick ride. Get you out of here.
This wasn't improvised. Let's examine what the law authorizes and what it doesn't. The Nordstrom gift card recovered from the subject's person constitutes physical evidence derived from both the confession and the loss prevention investigation. Under United States v. Patane, 2004, physical evidence obtained following a Miranda violation is not automatically suppressible, unlike testimonial statements. The gift card's evidentiary value survives even if any pre-waiver statement is challenged. Officers photographed, documented, and retained it chain of custody is intact. The trespass ban issued by Nordstrom and mall security operates as a civil enforcement mechanism entirely independent of the criminal prosecution. Criminal trespass attaches only upon the subject's return to the prohibited property after formal notice, which was given on camera with specificity. The officer's pre-transport advisement regarding concealed contraband is legally sound. It creates opportunity for voluntary disclosure and reduces institutional liability. Now for the grades. The responding officer receives a B+. Miranda was administered accurately and in full. Evidence handling was procedurally correct. Demeanor was professional throughout. The single procedural gap, the absence of a documented waiver before resuming questioning. Under current case law, this is survivable, but it is avoidable. The subject receives a C. Physical compliance and non-resistance are credited. However, every substantive legal protection available to him was voluntarily surrendered. After receiving a complete Miranda advisement, he provided a detailed, unprompted confession covering mechanism, intent, and scope. His statements are the prosecution's primary exhibit. Nordstrom Loss Prevention receives an A-. The pre-arrival investigation was thorough, well-documented, and properly coordinated with law enforcement. The deduction: no indication the subject was informed of his right to decline. Speaking with private personnel, a best practice gap in institutional LP protocol. 3 lessons from this footage. First, Miranda waiver should be documented on camera. A simple question, do you understand these rights, and are you willing to speak with me, eliminates an entire line of appellate attack. Second, private loss prevention interrogations are legally permissible but carry institutional risk. Advising subjects of their right to decline speaking is both ethical and strategically sound. Third, suspects who speak after Miranda without invoking build the prosecution's case for them. The right to silence exists precisely for situations like this one. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.